All right, folks, welcome back to the channel. Today we are diving into a major development, a big one for the Second Amendment. It looks like the Supreme Court's hand is about to be forced. There is another case challenging a so-called assault weapon ban, heading right to their doorstep. This one coming out of Connecticut. And frankly, this might finally be the one. This could be the case that forces the United States Supreme Court to answer that one question. The one they have been dodging for years now. Can the government just ban the AR-15? Can they ban the most popular rifle in all of America and just get away with it? Now, I've read this petition front to back, and let me tell you, it is one of the strongest, most direct challenges to these bans that I have ever seen. This one is different. The state of Connecticut. Well, they're in trouble. This is a good one. Make sure you hit that like button, share this video, and get subscribed, because you are not going to want to miss the critical updates as this thing moves forward. All right, so this is what's happening. The Connecticut Citizens Defense League, the CCDL, and the Second Amendment Foundation, SAF, have joined forces. They're backing the individual plaintiffs, Eddie Grant and Jennifer Hamilton, and they are petitioning the Supreme Court to strike down Connecticut's sweeping assault weapon ban. Now, this is the same kind of garbage ban we're seeing in all these other states, right? Illinois, New York, California, Massachusetts, Washington. The list goes on. But this petition, this one, brings something new to the table. It lays out one clear, direct question for the Supreme Court. And here it is, quote, whether the Second and the 14th Amendments to the United States Constitution guarantee the right to possess semi-automatic rifles that are in common use for lawful purposes, including the most popular rifle in the country, the AR-15. That's it. It is direct, it is to the point. No games, no side issues, no confusion, just one single clear question. And that is exactly why this case is so dangerous for the anti-gun states, and why it is so critical for the future of the Second Amendment. So, Connecticut's law bans the sale, the transfer, and the possession of a massive list of firearms that they label assault weapons. But let's get right to the truth, and this petition makes this crystal clear. Assault weapon is a political creation. It is not a technical category. It's a term that was invented back in the 1980s specifically to confuse the public. It was designed to blur the line between fully automatic military machine guns and the normal, ordinary, semi-automatic rifles that we all own. Under Connecticut's law, if a semi-automatic rifle has certain cosmetic features, or if it can accept a detachable magazine, or even if it has a barrel length or an overall length that they just don't like, it suddenly becomes an assault weapon, and it is banned. We're talking felony charges, including mandatory jail time. The law bans over 70 named firearms, plus any copies or duplicates, plus braced pistols, plus AR-styled rifles, plus any rifle with just basic ergonomic features. It is a functional outright ban on the most commonly owned rifle platform in the entire country. Now, this petition absolutely hammers the main point. And if the Supreme Court is faithful, if they actually follow their own precedent in Heller and in Bruen, Connecticut's ban cannot survive. None of them can. Here's what the petition lays out, plain and simple. Number 1. AR-15s are the single most popular rifle in the United States. Period. They say 20 to 30 million of them are in circulation. Honestly, I think those numbers are very low. We know for a fact there are more AR-15s in America than there are Ford F-150 pickups. Number 2. Americans use these rifles for lawful purposes every single day. Owners report using them for home defense, property defense, target shooting, training, hunting, protecting themselves and their families. The NSSF's own data shows millions of people train with them every year. Hell, I just got off a mountain, spent 3 days in the wind and the cold and the snow, learning how to better use my AR, read the wind, and be effective out to 600 yards. And number 3, the crime data just destroys their dangerous and unusual argument. According to the FBI, rifles of any kind, including ARs, are used in a tiny, tiny fraction of homicides. Handguns are used 18 times more often. Knives, and even hands and feet, kill more people every year than all rifles combined. If you applied Connecticut's logic consistently, you'd have to ban handguns first. And the Supreme Court already stomped that idea out in Heller. Now, the Second Circuit Court, the one that upheld this ban, their reasoning was so sloppy, so contradictory. The petition just dissects it line by line. The appeals court literally said they were confused about whether AR-15s even qualify as arms under the Second Amendment. Yeah, they really said that. They applied a watered-down history test. They deferred heavily to what the legislators wanted, which is something Bruen specifically forbids. They even said a firearm can be dangerous and unusual, even if millions of people own it. That last part is just insane. It is the exact opposite of what Heller said. The petition calls this out beautifully. A weapon cannot be both in common use and unusual. It's logically impossible. And this is why the Supreme Court has to step in. The lower courts are a complete disaster. They're all over the place. You got that circuit split that we're always talking about? Well, this petition just smacks them in the face with it. You've got the First Circuit saying ARs are arms, but they can be banned anyway. You got the Fourth Circuit saying ARs aren't even arms. The Seventh Circuit says they're basically military weapons. The D.C. Circuit is looking at lethality. It is a judicial patchwork of total contradiction. And this is where the petition delivers its most devastating line. And I quote, AR-15s are the modern descendants of the rifles our forefathers used to secure independence. Man, that is powerful. It reminds the court that repeating firearms existed in the 1700s. It reminds them that high-capacity arms existed long before the AR-15, that semi-automatic firearms have been in common use for over 140 years. The founders themselves embraced technological advancement. You had the Belton 16-shot rifle. You had the Girandoni air rifle that Lewis and Clark carried. The tradition is crystal clear. If a weapon is in lawful common use, it cannot be banned. Period. The petition quotes Heller, Bruen, Catano. It even quotes Gorsuch, Thomas, Kavanaugh, and Barrett's own writings right back at him. They even cite Kavanaugh's warning from earlier this year, saying this AR-15 question must be resolved. Well, this is the term. The petition explains that this case is the perfect vehicle. It is clean and simple. It has only one issue. It's got a clear circuit conflict. It is of massive national importance. It directly challenges a ban on the most popular rifle in America with no distractions, no other claims, and no procedural flaws. Plus, you've got the Second Amendment Foundation and the Connecticut Citizens Defense League behind it, two groups that know exactly how to litigate these cases with precision. If the Supreme Court wants to finally reaffirm what common use means, so even these lower court judges can understand it, this is the case. Patriots, this could be the one. This could be the most important Second Amendment case since Bruen and Heller. And depending on what the Supreme Court does, we could see Connecticut's ban fall, Illinois' ban fall, California's, New York's, Massachusetts, Washington's, all of them. They are all on the chopping block. Now, you know I'm going to follow this case every single step of the way. Make sure you are subscribed, hit that bell icon, and share this video. We need more gun owners to know exactly what's at stake. The fight for the Second Amendment is not slowing down. It is heating up. Make sure you like, subscribe, and drop a comment down below. Stay sharp.